January 2025. The prosecutor is Mr. Tambo, the solicitor is Mr. Bagani, and the defense are the state to proceed. Worship, this matter is on the road today for a formal identification. The accused having a previous conviction, this makes it Schedule 5, Your Worship. Therefore, it is in the interest of justice that the accused show this court that she can be released, Your Worship.
Madam, which day she proceeding? Madam, you prefer to stand or to be more comfortable to receive?
As the court pleases, thank you, Your Worship. I confirm my appearance on behalf of the accused, or rather the applicant in the proceedings. My appearance on instructions of DF Oosthuizen Incorporated. Mr. Oosthuizen is also present in court this morning. Your Worship, should I be making use of this mic or?
We are unfortunately not on the court. We are proceeding with
Court pleases. Your Worship, I submit that the state and the defence is in agreement with regards to the schedule, that it is in actual fact a Schedule 5 offence. If, with the permission of this Honourable Court, if we can ascertain from the state whether the application is opposed, and if the application is opposed, on what basis it is opposed. Apart from the fact that the burden of proof is on the applicant to persuade this Honourable Court that the interest of justice permits her release on bail. If it pleases Your Worship, we are in a position to proceed.
The state is not opposed to bail in this matter, Your Worship. The onus does still rest on the accused.
As the court pleases, Your Worship, in pursuing and moving the application on behalf of the applicant, we will do so by manner of affidavit. We have a rather lengthy and voluminous affidavit. Would you wish to read same into the record? Thank you. May I hand you the original and then perhaps proceed from the copy in my possession?
Yes, please.
Court pleases. If it pleases you, may I proceed? In the Magistrate's Court for the District of Soweto, held at Protea, in the matter between Makhotso Mapakiso Mofokeng, applicant, and the state, the respondent, affidavit in support of release on bail. I, the undersigned Makhotso Mapakiso Mofokeng, hereby state under oath that Roman Law 1 at introduction, paragraph 1, I'm the applicant in this matter. Affidavit is made in support of my release on bail, which I submit will be in the interest of justice for the reasons I stated below. The facts contained herein are within my knowledge and are both true and correct. I'm awaiting a bail application to be brought before the above-mentioned Honourable Court as a matter of urgency. My legal representatives have advised me that it is now considered law and practice that in bringing bail applications and to expedite the application, neither the defence nor the state has to present viva voce evidence. Still, it may rely on the mere production of affidavits and annexures. Paragraph 5. I've been advised to depose to this affidavit for purposes of my application to be released on bail. The content of my affidavit is based on my observations, knowledge, and legal advice obtained. I confirm that the respective meanings of the relevant legal terms and/or legislation were comprehensively explained to me. Roman Law 2 at personal particulars, paragraph 6. I'm a South African citizen with identity number 86 08290273 087 and am 38 years of age. Find a copy of my identity document attached here to marked annexure NNN1. I possess a valid passport which I will surrender to the investigating officer if the court orders me to. I did not have any, or rather I do not have any travelling documents of any nature. Find a copy of my passport annexed here to mark annexure NNN2. Paragraph 7, I reside at number 193 Bugle Avenue, Mondia, with my biological mother, my brother and my 3 minor children aged 12 years, 8 years and 6 years respectively. My husband and his daughter, my stepdaughter, also reside with us since we got married in 2024. I've been residing with my mother for the past 27 years. Find Annex here too, a copy of my proof of address of my business, marked Annexure NNN3. We are currently awaiting the completion of the restoration of a house I bought in Fairlands, Randburg, where we will move to upon completion. If I am released on bail, I will reside with my family at my place of residence upon completion, referred to Supra. 8. I married my husband, Sabelo Ngube, on 15 January 2024 in Johannesburg. A copy of our marriage certificate is attached here to and marked Annexure M4. Paragraph 9.1, I'm self-employed as a traditional healer and practice as such. As a traditional healer by occupation and as depicted from the copies of my passport, I travel frequently through Africa in search of conventional herbs and products. I therefore need to retain my passport and be allowed to travel abroad in search of traditional herbs not commonly found in South Africa. Previous travel to countries abroad includes in inter alia, Botswana, Namibia, Kenya and Mozambique. I do not have relatives and reside outside the boundaries of South Africa. My parents were divorced in 2002. My father will turn 60 years of age in March 2025, and my mother, whom we reside with in Mondia, is currently 65 years old. Point 2. As already stated, I'm a traditional healer by occupation, and I'm presently employed by my company, G. Maweni Productions, Pty Limited, bracket, G. Maweni Productions, close bracket, with its main place of business at 193 Beelville Avenue, Mondia. The business is therefore run from my residence where we all reside. I submit that I have 4 employees in my employment who will suffer if G. Maweni Productions is unable to generate any form of income. Find the relevant separate documents attached here to marked Annexure M5. Once my new home is renovated, the business will be relocated to my home in Fairland. Point 3. I've been a traditional healer for the past approximately 15 years. I submit that I'm also regularly on TV and radio and have a reality show and a social media following of more than 1 million people. I do charity work and annually host a women's conference where well-known motivational speakers are guest speakers and different goodie packs are handed out to the audience. I also hand out food parcels at my home to needy people. I deliver sanitary pads to schools and hand diapers and baby food to children's and welfare homes. I also do frequent school drives in KZN where I buy school uniforms and shoes for needy children who cannot afford them. I do at least one event every 4 months, and my social media, bracket Maweni Cares, close bracket, is updated with pictures and comments of these events regularly. Point 4, I humbly submit that I'm a well-known person, not only within the local community, but countrywide. Paragraph 10, I respectfully reiterate that I have 3 minor children who reside with me. My children have no contact with their fathers, and none of their fathers contribute to their maintenance at all. All my children are dependent members on my medical aid. I submit that I'm the primary caregiver of my 3 minor children. My children are dependent on my daily physical, emotional, and financial support. I have a very close and loving relationship with my children. My arrest and subsequent incarceration have left my children extremely traumatized with an unbearable emotional burden. Paragraph 11, I submit that I'm pregnant with twins. I attach here to a copy of my ultrasound scan confirming that I expect twin babies, marked Annexure M6. I pause to state that at Johannesburg prison, where I've been detained since my first appearance in court, I was again tested to confirm my pregnancy, whereafter they relocated me to the section for pregnant women. I am on a treatment plan to receive special medication for my pregnancy. This medication is essential to support my pregnancy and to ensure the best outcome for the babies. However, I am not allowed any prescription medication in prison, and the medication they supply me in return makes me nauseous and causes me to vomit. It also suppresses my appetite, which is not good for my pregnancy. I'm also required to follow a specific diet to support a healthy pregnancy. I attach here to the report from Vita Lab dated 20 January 2025 confirming my required treatment as Annexure M7. I respectfully submit that my continued incarceration might result in a life-threatening situation for my unborn babies and me. Paragraph 12.1. I attended primary school at Crown Reef Primary and high school at Mondia High School. I matriculated at Maryvale High School, Orange Grove. 2. I generate an income of approximately 70,000 Rand per month from the proceeds of my company. As stated above, I do not receive any maintenance for the minor children from their biological fathers. I alone contribute towards their upbringing and maintenance. Point 3, I own the immovable property bought in Fairlands, Randburg, bracket 107 5th Avenue. I'm busy doing renovations to this property, and upon completion, we, bracket, me, my husband and our children, close bracket, will move there too as a family. I also own a property in Deep Kloof, Zone 4. I rent this property and receive an income from the rent of 18,000 Rand per month. I also own a townhouse in Oakdean, Balboa Park, and my rent income from this property is 8,000 Rand per month. Point 4, the value of the immovable properties is approximately 4.5 million Rand. The properties are not bonded. Point 5, I possess movable assets, bracket, household furniture, fittings, and appliances, close bracket, of approximately 400,000 Rand, excluding personal belongings and clothing. I also possess a BMW 420i 2023 model with a market value of approximately 650,000 Rand, and a Ford Ranger LDV 2014 model with a value of approximately 300,000 Rand. The Ford Ranger is paid in full. Paragraph 13, I submit that my residential address is valid, fixed, and within the jurisdiction of the above mentioned Honourable Court, where I will stand trial. My residential address should be common course between the state and the defence. 14, I have an amount of 5,000 Rand available for bail, but will be able to raise further funds with the assistance of my family and friends should the court find a higher amount appropriate. Roman Law 3, history of antisocial behaviour. Paragraph 15. Point 1, I have the following previous convictions. Point 1, I was convicted of assault GBH in 2017 and was sentenced to a suspended sentence. Point 2, I was convicted of fraud in about 2015. I was accused of fraud by my employer because I passed the credit for product that I bought from them and did not let a different manager do it. As far as I can recall, I did community service for 3 months. I'm unable to recall the exact sentence I was imposed. Point 3, I also pleaded guilty to driving under the influence of alcohol approximately 15 years ago. I do not recall the sentence handed down, and a recent application for police clearance before travelling abroad did not reflect the conviction. Point 4, I mentioned to my previous attorney of record that I do not remember the exact details of my previous convictions or sentences. During my first court appearance, she may have mentioned that I do not have any previous convictions or sentences, although I am not entirely sure. I submit that I'm a lay person when it comes to court procedures, despite my previous encounters with the law. Your Worship will notice that 15.1.5, if you perhaps, if I may request you to turn the page, there's an inserted page at the back, and I will then return to the previous page, and I will then proceed reading from 15.1.5. Apart from the above, there might be further previous convictions that I failed to disclose. My failure to disclose is not the result of malice or to mislead the court. I submit that I never expected to be arrested and treated this way. I was extremely traumatized and confused because of my arrest and detention. As a result hereof, I started bleeding. It appears that a misunderstanding between me and my previous attorney happened. I meant to say that I have previous convictions, but the nature and the detail thereof I could not recall. I unequivocally state that I did not intend to mislead the Honourable Court, as my freedom depends on this application. I then take you back to page number 8, Your Worship, 15.2. I do not have any outstanding or pending cases. Paragraph 16. I confirm that no order contemplated in terms of Section 5 or 6 of the Domestic Violence Act 1998 has ever been made against me. I further confirm that no order contemplated in terms of Section 3 or 9 of the Protection from Harassment Act 2011 has ever been granted against me. No orders of a similar nature have been granted against me. Paragraph 17. And I take you then, Your Worship, to page number 9. I am not placed under correctional supervision, day parole, or medical parole as contemplated by Section 73 of the Correctional Services Act 1998. 18. I've been informed that failure to disclose the above mentioned aspects constitutes an offence. I'm aware of the consequences thereof. Roman Law 4 charges, factual background thereto. Paragraph 19. I've been informed that I stand trial on a charge of assault with the intent to cause grievous bodily harm, brackets GBH. Both my legal representatives and I have not been afforded an opportunity of access to the docket. I'm therefore unaware of the exact nature of the charges and or allegations made against me. 20. Should it be required to amplify any aspects contained in this affidavit, I wish to reserve the right to give oral evidence and or a further affidavit at a later stage in support of this application. I therefore reserve the right to request my case to be reopened to give effect to the aspects referred to supra. Point 1. I vehemently deny being guilty of any offence and will most certainly plead not guilty to any charge the State may prefer against me at my trial. I've been advised by my legal representatives that I have a constitutional right to remain silent and that it is indeed prudent to do so at this stage. I will, notwithstanding my constitutional rights, concisely tender the basis of my defence. Point 2. I submit that a detailed version will be placed before the trial court and during the trial procedures. Point 3. On the morning of 19 January 2025, the police went to my Fairland property looking for me. I was in Mondia at the time when they called me on my cell phone. The police then went to my Mondia residence looking for me, but I had already gone to the Mondia police station to find out why they were looking for me. Upon my arrest, I was informed that the SAPS could not get hold of me and that I was arrested for allegations of GBH allegedly emanating from an incident in December 2019. Point 4. I respectfully submit that I find it extremely strange that the police could never get hold of me. I'm a public figure and well known with a huge social media following. I have resided at the Mondia residence long before the day of the alleged incident. I emphasize that I've been residing at the very same address for approximately 27 years. I submit that the SAPS evidently had the details of my residential address, hence contacting me and looking for me at my residence. Point 5. I appeared before this Honourable Court on Monday 20 January 2025 and the matter was postponed to 27 January 2025, during which I was ordered to remain in custody until then. 6. The complainant in the matter is the cousin of my third son's father, Siyabonga Zulu. Point 7. On the day of the alleged incident, I attended a public appearance in Soweto. The complainant and her friends or family were there too. About 5 people approached me in the street and started shouting and screaming at me. The verbal abuse turned violent and I had to defend myself against these attackers. Siege Zulu was one of them. My phone was stolen during the altercation. Members of the public intervened and pulled the attackers off me. I then left for my home. Point 8. At the time, I filed the criminal charges against the complainant and her accomplices at the SAPS. After having filed charges, I never heard from the SAPS again. Apart from phoning the police station on a few occasions, inquiring into my complaint, I did not pursue the matter. The incident transpired more than 5 years ago. The matter serving before the Honourable Court appears to be a classic example of 2 persons having filed counter charges against each other, wherein only one of the complaints is investigated and pursued more than 5 years after the fact. I submit that I was the victim in the matter and not the complainant. Point 10. The complainant and my third son's father, Siyabonga Zulu, knew my details and whereabouts all along. 11. I vehemently deny having committed any offence of any nature. I submit that I raised a bona fide defence. I submit that the State has a weak case against me. I will in all probability be acquitted upon the conclusion of the trial. Roman Law 5. Submissions regarding factors to be considered when deciding whether bail should be granted. Paragraph 21. I'm advised that my application resorts within the ambit of Schedule 5 of the CPA as a result of the nature of the allegations and previous convictions. 22. I've been informed that if the Honourable Court finds that my application indeed falls within the ambit of Schedule 5 of the CPA, I bear the onus to prove that the interest of justice permit my release on bail. I respectfully submit I'm not required to prove the absence of factors different to normal considerations listed in subsections 4 to 9 of Section 60 of the CPA. Roman Law 6 considerations in terms of Section 64A to E, read for Section 65 to 68, capital A of the Court Procedure Act. Section 64, subsection 4, paragraph A. 24. I respectfully submit I do not pose a threat to the safety of the public or any particular person. I harbour no resentment towards any person and have not threatened any person in this matter. I submit that the allegations are serious. I submit that I'm presumed innocent until proven guilty. I respectfully submit that my release will pose no threat to society. I respectfully reiterate that I do not have any outstanding case. Section 60, subsection 4, paragraph B. Paragraph 29, I will not attempt to evade my trial. I submit that I'm a stable, contributing member of society and I'm not a flight risk. I'm a positive individual and in the process of getting the strings of life together again. I submit I'll be staying in a stable, contributing environment if released on bail. I understand that the charge against me is serious. A stern punishment may be imposed by the Honourable Trial Court if I am convicted. I, however, respectfully submit I remain presumed innocent, and I'm confident that I will be found not guilty of the charges. 32. I will abide by any bail conditions the court should deem fit to impose. I submit that my pre-arrest conduct is indicative of the fact that I will stand my trial. I submit that my husband informed me that the police were looking for me. I approached the SAPS at the Monday police station alone to inquire into the reason for the SAPS looking for me, whereafter I was arrested and detained. I submit if I had any intention to abscond or not to cooperate, I had adequate opportunity to. 33. I submit that my business is dependent on my daily input. I will in all probability have to close down my business down if I am not released on bail. Section 60, subsection 4, paragraph C. Paragraph 34. I respectfully submit there is no chance of any interference of any nature. I'm informed that relevant witness statements have already been obtained. I'm informed that the matter emanates from an alleged incident in 2019. Therefore, the investigation should have been completed a long time ago. 35. I will refrain from interfering with any of the state witnesses. Section 60, subsection 4, paragraph D. I submit that my release on bail will not undermine or jeopardize the objectives of the proper functioning of the justice system. I've not supplied any false information in this matter, and there is no indication in my past conduct to show that I will not comply with any of the bail conditions. Section 60, subsection 4, paragraph E. I submit that there are no exceptional circumstances present to indicate that my release will disturb the public order or undermine public peace or security. Roman law 7, at section 60, paragraph 9, or subsection 9, prejudice, the applicant is likely to suffer if bail is denied. Paragraph 39, conditions prevailing in prison are not conducive for human use. I will be unable to comprehensively consult with my legal representatives and will be prejudiced in the preparation of my defense and my subsequent trial. I submit that I will be severely prejudiced should bail be refused. I respectfully submit that my children are in desperate need of my physical and emotional support. They are traumatized by my incarceration. My incarceration has placed an immense emotional burden on my family. Due to my mother's age, she is unable to care for my children and their respective and specific needs. My health condition is not good, and for the reasons advanced supra. I'm pregnant with twins, unable to function in prison, and do not have access to my much needed medical treatment and medication. The prison does not cater for my specific dietary needs referred to supra. My continued incarceration might very well result in a miscarriage and a life-threatening situation for me. The circumstances prevailing in prison are simply not conducive for a pregnant lady like me. My condition renders me a soft target for criminal activities prevailing in prison. Paragraph 42. If I'm not released from custody, I will not be able to generate any income of any nature. My business requires my specific skills and daily input. I will eventually have to close my business down. My husband will be unable to meet our financial obligations, and my family will suffer and will be prejudiced. I respectfully reiterate that I have 4 employees in my employment. The employees and their respective families are dependent on the income they receive from Gogo Maweni Productions. My employees and their families will suffer undue financial prejudice if the business is unable to generate any form of income. I'm informed that trials such as mine might take up to 2 years to conclude. Even if I'm eventually acquitted upon the finalization of my trial, the detention will have a devastating and punitive effect on my life. I submit that no likelihood exists that any grounds referred to in section 60, subsection 4, paragraphs A to E of the CPA will incur. I further submit that the interests of justice can be found in my circumstances, the factors referred to supra, cumulatively assessed. I therefore humbly submit that I have indeed deduced evidence that it will be in the interest of justice that I'm released from custody. Request the Honourable Court to fix bail to an amount and with any appropriate conditions that the Court should deem fit. Paragraph 46, I will comply with any bail condition until the conclusion of my trial. Your Worship, it has been duly so signed by the applicant in the proceedings, and the application has been commissioned. If the applicant admits the contents of the statement, I will humbly request Your Worship to accept same into the proceedings as Exhibit A, as it pleases Your Worship. the court pleases. Thank you. That will then be the case for the applicant.
As the court pleases, Your Worship. Your Worship, the state has already informed the court that it is not opposing the bail in this matter. However, there are submissions that the state has, Your Worship. Firstly, the state has a bail statement that is being deposed to by the investigating officer. We would like to read that, Your Worship. I am an adult male employed by the South African Police Service with service number 0529 599/8. I am stationed at the Gauteng Province Cold Case Investigation Unit at number 41 Gubiso Avenue, holding the rank of a captain. The accused in the above matter, Makgotso Mofokeng, is also known as Gogo Maweni, has previous convictions for the same offense she is now charged with. She was arrested and charged with assault with intent to do grievous bodily harm as per Kliptown case number 35/05/2017. The accused was then convicted on the charge and sentenced to 3 years imprisonment, which was suspended for 5 years. It is upon this ground that I oppose that the accused be released on bail, in that she committed this offense while under a suspended sentence for a similar offense. In a case where the court arrives at a different conclusion, other than the one that I prayed for, I wish that the court should put stringent bail conditions, and also that the accused surrender her travel documents to the state. That is all I would like to state for now regarding the bail proceedings. The statement, Your Worship, has been signed and duly commissioned. The state begs leave to hand it in for it to be marked as an exhibit. So, pleases, Your Worship, the state is also in possession of SAP 69s of the accused. May we read that, Your Worship? On the 14th of October 2009, the accused was found guilty of contravention of the Road Traffic Act, was sentenced to a suspended sentence for 2 years. On the 29th of September 2017, the accused was found guilty of assault. The sentence was 1,500 rand or 3 months in prison, and that was wholly suspended for 5 years. On the 24th of July 2018, she was found guilty of fraud. The sentence was count 1 and count 2 taken together for the purpose of sentence. 20,000 rand or 6 months imprisonment, which was wholly suspended for 3 years. Again, on the 24th of July 2018, she was found guilty of fraud, and the sentence was also taken together for the purpose of sentencing. 20,000 rand or 6 months imprisoned, which was wholly suspended. Another count of theft on the 27th of July 2018, also taken together with the previous one. 10,000 rand fine or 3 months imprisonment, which was wholly suspended. Count 4 was of theft as well. 24 July 2018, also taken together with the previous ones. Your Worship, the state begs leave to hand in the SAP 69s for them to be marked as an exhibit. Support pleases.
I'm just referring to this fraud and theft matter in 2018. It says 2018, 24th of July. fraud that committed 15 August 2016. Then it's printed again, page 3 of 4, 2 of 4, 3 of 4. Count 1 and 2 taken together. That is a duplicate. And then the next page 3 of 4, that is a duplicate. And then the same one, but then it says count 3 and 4. So it's count 1 and 2 taken together. Count 3 and 4 taken together. And then further in terms of section 276(1)(h of the Criminal Procedure Act, usually sentenced to 12 months probation supervision. So it seems that in 2018, July the 24th, there was a charge of fraud, count 1 and 2, count charge of theft, count 3 and 4. So it's unclear whether it was 3 and 4 alternative, but it sounds like it was fraud 1 and 2, theft 3 and 4.
Indeed. My inference from what the prosecutor placed on record was that it's one case number, counts 1 to 4, 1 and 2 fraud, 3 and 4 theft. Yes, but it was one case.
One case?
Yes.
And then it was, I think altogether it was 276.
That, yeah, correctional
One
supervision. 276 yes.
Arrest and then 12 months.
Correct. That is what I infer from the 69s as well. Thank you, Worship.
Just wanted to make that clear. Because there's a duplication on between page 2 and 3. When you read it. SOP 69 is not
As the court pleases, Your Worship. Your Worship, the state would also like to submit that when considering whether it is in the interest of justice that the accused be released on bail or warning, Your Worship, that the court be reminded of the first appearance of the accused before this court. She was asked, Your Worship, she was legally represented, and her legal representative informed the court she had no previous convictions, despite the previous convictions that had been handed to this court. The state is of the view that this shows that the accused was dishonest to the court, Your Worship. And also to inform the court and the accused that the state will be adding a charge of failure to disclose. The court should also take into consideration the assault of 2017. It is a similar charge to the one that the accused faces today, Your Worship. And the investigating officer also mentioned this in his statement, which shows that the accused before court has a propensity of committing offenses, similar offenses in that case. Just after 2017, where she was on a suspended sentence, 2 years later, she finds herself having committed the same offense. This is something that the court should take into consideration when it makes its decision. Further to that, Your Worship, the state is in possession of an A1 statement, and just to reiterate that the complainant is well known to the accused, and after the incident occurred, there were threats that the accused uttered to the complainant. The state would like to read a short paragraph, Your Worship, to the court. It is A1 statement deposed by Kulu Eliwe. Paragraph 4. My sister Mbali of 46 Salukanda Street, Zamini, heard the noise and then she came out immediately and she took me inside the house to clean myself. I then went to the clinic as my mouth was having a big cut. When I was at the clinic, Makhotso followed me and she was insulting me there at the clinic, telling me that she fears nothing and she has the money to bribe the police to drop the case. This is also some information that the state would like the court to take consideration of, Your Worship. The threats that the complainant endured after this incident occurred. With that said, Your Worship, that is the state submissions. As the court pleases.
Court pleases. Your Worship, this is a Schedule 5 offence. It is so that it's incumbent upon the applicant to prove on a balance of probabilities that the interest of justice permits a release on bail. Your Worship, if we look at the papers that have been submitted to yourself, none of the personal circumstances contended by the applicant have been disputed by the state. Moreover, the fact that the accused is of ill health, she's pregnant with twins, she's not getting the medication, much needed medication, and we have adduced evidence in support of this contention. It's not a bold allegation, and this is accepted by the state. I respectfully submit, if I refer you to State versus Hartsleaf, State versus Sawela, and I have the full citations of the cases, if whatever the applicant states and is prima facie, and if the state does not adduce evidence to contradict and rebut, it becomes conclusive for purposes of this application and these proceedings. I submit with respect, what is it that you can accept? And I'm not going to repeat it. Everything that is said as part and parcel of the personal circumstances. Because it has not been gainsaid. It has not been disputed by the state. More particularly, the defense that the accused, or rather the applicant, has disclosed. It's a bona fide defense. Nothing was adduced from the state side to contradict the prima facie, bona fide defense that the accused has raised. It's a Schedule 5 offense. The merits of the matter is not that important as it is in a Schedule 6. However, it's a factor to be considered. And this is a factor weighing heavily in favor of the applicant. Your Worship, you're dealing here with a matter where the applicant, or rather this is common cause. This incident has transpired between known people 5 years ago. The arrest only took place now. The applicant stated she also filed charges, and it appears to be of assault and theft of a cell phone. Nothing came from it. The state is not disputing it because the state has not adduced any evidence to the contrary. I, however, do not wish to dwell on these aspects. It is clear that the state is not opposing. They placed it on record. The state is not opposing bail. I understand that this Honourable Court is not a rubber stamp and is still the master of our own proceedings. If I may respond to what my colleague has placed on record. My colleague has placed on record an incident in paragraph 4 of A1 statement, which purports to be a statement deposed to by the complainant. That statement has not been submitted as evidence. First of all, the prosecutor's address has no probative value, and I submit this with respect. But even if it had, it has no bearing on what transpired today and what is transpiring today. I respectfully submit that if there were any threats, Your Worship, there's no allegation that something happened to the complainant. If it in fact happened, it is clear and evident that it must have been empty threats. We, in actual fact, vehemently dispute such an allegation, with great respect. Your Worship, with regards to the previous conviction, we dispute that the applicant was dishonest to this Honourable Court. We have provided you with an explanation. Is it an unreasonable explanation? Although she had previous encounters with the law, we're still dealing with a lay person. She has provided you with a plausible explanation. Is there any reason not to accept it? I respectfully submit there is not. Your Worship, does that have a bearing on granting bail? It can never have. Look at, and I submit with great respect, the conduct of the applicant, her pre-arrest conduct. She was phoned. She said, I'm at my house. Or her husband was phoned. She went to Mondia police station. She said, here I am. She's got nothing to hide. She surrendered herself. She did not have to be arrested at her place of residence. How do you anticipate someone's future conduct? By looking at the past conduct. And the past conduct is without any criticism. I respectfully submit. My learned colleague, from what I gather, the investigating officer, although the prosecutor placed on record that they're not opposed to bail, wants to oppose bail on one aspect, that she has committed an offence of a similar nature.
Before we move on, can I interrupt?
Yes, please, Your Worship.
Let's go back to 20 January when you were not counsel.
Yes.
And this court was the attorney of record there said to this court, it is my instructions clearly that the accused then, because it was not over, the accused has no previous conviction.
Yes.
Was not said once, was said multiple times. And when this court then asked the state, do you have a profile or is it the state said no, we do not have that as yet. But it was a conversation between the investigating officer and the state prosecutor, who then said to the investigating officer, who said to the state prosecutor, there's indications of previous convictions. The attorney then said to the court that should the investigations not have been finalized by should the SAP 69s not have been that is not my possibility, but she already indicated that she spoke to the accused and the accused was denied. And then we were talking about one previous conviction of 2017.
Yes.
Now the court is in possession of the SAP 69s.
Your Worship, as you very well know, I was not the legal representative of record.
You are saying to the court now that the applicant was traumatized.
Yeah.
But she went to the Mondia police station to hand herself over. What was her thinking when she handed herself over? What was it in connection with?
Yes.
And she handed herself over on Sunday at 3 o'clock. She appeared on the 20th, that is 19th. She appeared on Monday, the 20th.
Yes.
I cannot remember the time that she appeared on the 20th. Did she forget between the 19th and the 20th? But she had been previous conditions.
Yes. Yes. Your Worship, I think what we're trying to contend in my respectful submission is, when she approached the Mondia police station, she actually went there to find out why is it that they were looking for her.
Because nobody was
Yes.
5 years
Now,
ago something.
as a result of the arrest, she never expected that she would be arrested. That is contended in the papers as well. And as a result of the arrest and the subsequent detention, and of course the pregnancy, she started bleeding. That is our contention in my instructions. And I respectfully submit that her version is that she indicated to her then legal representative that she might have, she cannot remember it. And then it was interpreted in terms of my instructions. Yes. Yes.
The legal representative said to this, it is my instructions.
Yes.
From the applicant,
Yes.
she does not have any previous convictions. And the state is not in possession of the SAP 69s. The investigating officer is not here. He left.
If I may.
And remember, the accused, upon arrest, on the Sunday, she is informed what she's supposed to do. So she knew on Sunday she's arrested for assault and the intent was previous body harm to the complainant.
Yes.
So she knew on Sunday this was what she was arrested
Yes.
for.
Yes. We humbly apologize for what we feel was a misunderstanding at the time. It is so, Your Worship.
So yes. Then the court then heard there's a previous conviction in 2017 for also assault to the age. And then today, the P69 shows fraud. What does fraud entail? What's the one word that fraud entails? Dishonesty.
An element of dishonesty. Correct.
Dishonesty.
Yes.
What's the element that this entails today?
Yeah.
Dishonesty.
Well, that is now, Your Worship,
So
if...
we are now sitting in a position where the personal circumstances, because I do
Yes.
family, anything, 100% and she has caused all of this because of her dishonesty.
Yes. Your Worship, we're talking about an element of dishonesty if the court does not accept the explanation that the applicant is providing. The remedy, Your Worship, for the state in this instance is, and my colleague has placed it on record, that they're going to add a charge or even open a separate docket for purposes of the disclosure. Yes. Yes, and that will remedy, and that is where the state will find its remedy in the allegations that is proffered. So I beg and I plead to this honourable court on behalf of the applicant to accept or let it not be a bar against the granting of bail, but let us stand then trial on these allegations and let a trial court find whether her version of the events that she's disclosing now is acceptable or not, and not the bail court, and let the court not already, because of that mistake, punish her and refusing bail for the applicant. I respectfully submit, Your Worship, we know State versus Bronco, State versus Atchison, all those well-known decisions, and bail is non-penal in character. And if this honourable court has any remedy or any concern, it can be remedied by manner of the imposition of bail conditions. And I can refer you to State versus Wilkinson. It's the Supreme Court of Appeal decision. I have the full citation with me, where the learned judges indicated that it's a misdirection not to actively consider the imposition of bail conditions and to regard the refusal of bail as an absolute last resort. Your Worship, I hear what you say with regards to the previous convictions. Let's not lose out of sight that the accused stand trial on mere allegations at this stage. She's presumed to be innocent until proven guilty. Allegations that were made more than 5 years ago. Your Worship, with her specific individual circumstances, can it ever be in the interest of justice, bearing in mind that the state is not opposing bail, be in the interest of justice not to grant the bail? Your Worship, I can carry on and give you lots of case law on various aspects. I simply do not know whether that is in actual fact necessary in the light of my colleague that is not opposing bail. Yes, please. That is the indication. What my approach. Your Worship, yes indeed. I can also refer you to paragraph 15.1.2 where it is contended that it is in actual fact that the applicant's employer was involved. Your Worship, yes it is. Your Worship, what I perhaps 15.1.2, page number 7, what I'm perhaps, if I may,
I was convicted of fraud in about 2015. I was accused of fraud from my employer because I passed a credit for products that I bought from them and did not let the district manager do it. I did not understand.
yes. Yeah, I do not know the full details of the nature of the fraud and the theft, because obviously there was theft that was involved as well. I can perhaps just add, and I submit with respect, that the current charge that she's facing does not consist of an element of dishonesty. I understand what you say with regards to the non-disclosure. However, that charge has not been added yet. It might be a different docket, and if the state then so wish, they can oppose bail on that particular docket. And whether they're simply going to add it as count number 2, we do not know. It might be a misjoinder, I don't know. But that's for the trial court or even the next occasion, the magistrate to decide. And what is also important, that since 2015, or she says 2015, I think the allegation is 2017, if I'm not mistaken. But I think that the applicant makes it clear that she's not certain of the dates.
2017 was the assault.
Yes.
2018 was fraud.
Okay. But ever since,
Driving under the influence was 2019.
yes, ever since she walked the straight and the narrow, that was the last. That's approximately, we're going for 7 years. More than 5 years, 6, 7 years, and that's definitely also something to be considered. She's a well-known person, she's well-known within the community. I'm not going to repeat all the personal circumstances. Your Worship, it will be, unless there's anything else, I am of the respectful submission, in the face of the state not opposing bail, in the face of the contents of the application, as well as the plausible, in my respectful submission, the plausible explanation that has been provided, that the accused discharged herself from the onus that rested upon her. Is there anything else? Thank you.
Your Worship, just one last thing. The state would like to submit that if the court is of the view that the accused did discharge the honors, then the state will submit that her passport be confiscated and that she not be allowed to travel outside of the country for the duration of the trial. That's all that the state would like to add to that, Your Worship.
Okay, so I need to ask the state the reason for the delay. What is the investigating officer regarding the incident happened in 2019. I heard counsel say it's from a court case. It seems the matter has been dead. It's not been investigated.
Your Worship, according to the investigating officer, they were unable to trace the accused in this matter, and at that point they were also having difficulty tracing the A1, the complainant. Yes, that is according to the investigating officer.
Seems that the applicant was not difficult to trace. It seems that she's a well-known person, but the complainant opposed.
Understood, Your Worship. Yes, that is what
So that was the reason for
yes, that's the reason that the investigating officer provided.
And do you know of anything in the docket regarding the complaint?
Nothing about a counter charge, Your Worship. in this docket, nothing about a counter charge.
A1, that you read the paragraph wrong, that was made in 2019.
Indeed, Your Worship.
So threats that was made, those were made in 2019.
Indeed.
And there has been no contact between the officer and the complaint since 2019.
Yes, there has been no contact, Your Worship.
Your Worship, yes, thank you. Thank you for your indulgence. Your Worship, one last aspect. With regards to the passport and travelling documents, you've read, yeah, she travels, it's part of work purposes and to generate an income. It will be tantamount to denying her the opportunity and the ability to generate. I beg your pardon? The suggestion would be that perhaps she informs the investigating officer of each and every travel that she has outside the boundaries of Gauteng, outside South Africa, and perhaps provide the investigating officer with an itinerary and a copy of the flight ticket. That I am of the respectful submission will remedy any concern that the state might have.
The court is having another concern, if I can bring it up again.
Yes.
The addresses. I also want to
Yes.
have the investigating officer be informed of the situation.
Yes. That's perfect. Thank you, Your Worship. Whenever she moves to the new address as contended in the application, she will, in writing, inform the investigating officer of the position, as the court pleases. May I quickly... So the new address is also, it is in the documents. We will just formally inform you that the applicant is intending to move to this particular address. Court pleases.
Ready to proceed with judgment. Can be made sealed. In an application for bail, the court is guided by section 60, subsection 480 of the Criminal Procedure Act. The state and the defence both agree that this is a schedule 5 bail application, and therefore the court does not have to make an order in that regard. The Schedule 5 formal bail application, the onus rests on the applicant to prove that it's in the interest of justice that she must be released on bail. The Constitutional Court defined the concept of interest of justice in State v. Maweni, State v. Gogo Maweni, State v. Rivera, and State v. Ithaca as the following: that it is a value judgment of what would be fair and just to all concerned, and secondly, that the interest of justice must be interpreted to include, but not be limited to, the safety of any person against whom the offence allegedly has been committed. The court will consider whether the applicant, in terms of section 40, subsection 480 of the Criminal Procedure Act, A, endangered the safety of likelihood that the applicant, if she's released on bail, will endanger the safety of the public? There was no evidence that indicated today that the applicant, if she's released on bail, will endanger the safety of any member of the public or a particular person, specifically the complainant. There's no evidence that the applicant today will endanger the safety of the complainant, although she knows the complainant. In the 5 years that the matter has been pending or in being investigated, there's been no evidence that the accused or the applicant has endangered the safety of the complainant. Subsection B, whether there's a likelihood that the applicant, if she was released on bail, will attempt to evade her trial. There was no evidence that she will evade her trial. After she was contacted by her husband or by the police, she handed herself over to the Mondia police station. There was no indication that she will evade her trial. She has stayed for a period or resided for a period of 27 years in Mondial, so her address is well known. Subsection C, whether there's a likelihood that the applicant, if she's released on bail, will attempt to influence or intimidate the witnesses. There's no evidence today that she will attempt to influence or intimidate the witnesses or conceal or destroy the evidence, as in her mind that this case was not even being investigated. Subsection D, where there's a likelihood that the applicant, if she is released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. This matter was conversed with the counsel of the applicant today, with regards to the fact that the applicant today did not disclose in her first appearance her previous convictions. In subsection 8, subsection A, the fact that the accused, knowing it to be false, supplied false information at the time of her arrest or during the bail proceedings. The applicant did not disclose during her first appearance that she had the following previous convictions. In 2009, on the 14th of October, she was convicted of driving under the influence of alcohol, and her sentence was postponed for a period of 2 years. In 2017, on the 29th of September, she was convicted of assault with the intent to do grievous bodily harm and was sentenced to 1,500 rand fine or 3 months imprisonment, which was wholly suspended for a period of 5 years. And in 2018, on the 24th of July, she was sentenced to 2 counts of fraud and 2 counts of theft from her employer, and she was sentenced to, in terms of section 2761H of the Criminal Procedure Act, and this was also not declared by the applicant. The state has decided to remedy this is to charge the applicant with a further count instead of just the count of assault with intent to of grievous bodily harm, to also charge the applicant with providing false information during her bail hearing. The council has also stated to the court that this was done during her bail hearing due to the fact that she was traumatized, and she then did not disclose this information to her legal representative. The court has accepted this explanation from the council and from the applicant. And subsection E, where in exceptional circumstances there is the likelihood that the release of the accused or the applicant will disturb the public order or undermine the public peace or security. There's also no evidence of such. Therefore, the court will grant the applicant today bail in the amount of 5,000 rand. Court will make strict bail conditions for the applicant. So would you be taking instructions on the remainder of her case, or are you only instructed for the bail?
For the moment, I will be requested to be excused, but my instructing attorney, Mr. Westhuizen, will in all probability appear.
Can I, with you, arrange a date for further investigations?
Yes.
He's not road.
Yeah, he's not right. So,
Can I arrange with you?
more or less, how long will the state
We are
need?
looking at, I don't know if we are ready for copies, or are we doing further investigations?
Investigations are completed.
Further investigations are complete.
What is the procedure? Will it then be postponed for purposes of disclosure? And
Yes, we will postpone
so that
today
will be
for
the
further
purpose.
for copies, and on the next occasions copies will be given, and then matter will be transferred to a trial.
Approximately 2 weeks?
Suitable.
Any date in 2 weeks' time, if I'm looking at my calendar, if you don't mind. The 11th of February, the date is suitable to Mr. Westhuizen, sitting next to me.
It is suitable for the court as well.
Court pleases. Thank you, Worship.
Ma'am, you may stand up. The matter is now postponed 11 February 2025 for copies. Your bail is set at 5,000 rand. The court is making the following conditions: no contact with the complainant, direct or indirect. You have to inform the investigating officer of your itinerary when you leave the Republic of South Africa. You also have to inform the investigating officer of your date when you change your address and the address which you move to. Do you understand? Thank you. 8:30, court number 2.